Good Wednesday night to you. I am Thabo Mdluli, and thank you for joining us tonight here on the Newsfeed Late Night. In 2011, Judge Willie Seriti and Supreme Court of Appeal Judge Hendrick Musi from the Free State High Court was judge president at the time, were appointed to chair the Arms Procurement Commission, known as the Seriti Commission. Now, the commission probed allegations of fraud, corruption, impropriety, or irregularity in the 1999 arms deal involving former President Jacob Zuma and French company Thales. It ruled that there was no wrongdoing in the deal. Now a complaint that the two judges overlooked crucial information has been referred to the Judicial Conduct Committee to decide whether it should be reported to the Judicial Conduct Tribunal. Let's delve deeper into that story with the Director of Shadow World Investigations, Paul Holden. He joins me alongside Research and Advocacy Officer of the Judges Matter campaign, Mbekezeli Benjamin. Gentlemen, good evening and thank you very much for joining us tonight on the Newsfeed Late Night.
Thank you.
Good evening, Thabo.
Paul, let's begin with you then. I mean, you have brought this complaint following that High Court ruling in 2019. You brought this in 2020, but it's not the first time that issues were raised around that report. Why do you think it has taken this long for this matter to get this far?
I mean, sadly, the wheels of justice turn very slowly. I mean, the Seriti Commission reported its findings in, forgive me if I get this exactly, don't get this exactly right, but I think it's April 2016 they reported their findings. And it took a good 3 years for that matter to wind its way through the courts, the High Court in particular, to get to the point that the High Court could rule on it. I had some insight into that particular case, and the thing that really delayed that case was that the state was supposed to hand over all sorts of documents to Corruption Watch and R2K, and just failed to do so. So it became this very lengthy debate about which documents should be disclosed, which shouldn't be disclosed, and which delayed matters. I mean, I think we could see that, you know, with regards to Jacob Zuma, that if you want to delay court matters for a long period of time, there are avenues to do so. Now, once that High Court judgment came in, it obviously it took quite a while for the Chief Justice to consider our complaint. I mean, I think that it's appropriate for the Chief Justice to spend a decent amount of time considering the matter, because it is actually quite a weighty matter, which has some pretty profound implications for the lives of those judges who've been complained about, but also about the judiciary as a whole. Obviously, we would like this to move very swiftly and not to have a Judge Hendrick sort of situation developing. Hopefully that won't transpire here.
Highlight for us then what are the holes in this particular report. I mean, I've mentioned, for example, the fact that there were 4.7 million computer pages and 460 boxes of evidence that remained untouched. The fact that the president at the time, President Zuma, as well as the company Thales, were not called by the Seriti Commission. I suppose it's one of the issues that you're raising. What else are you seeing as holes in that report?
Sure. I mean, there was, it's hard to choose which one to emphasize because there were just so many. I mean, it really was frankly, it was a total disaster. And the High Court judgment, setting aside that report, was utterly damning. It really was. I mean, it basically found that the Commission of Inquiry, which it had one job really, which was to inquire, and it didn't do that job. It didn't inquire about anything. It made no attempt to gather evidence from overseas. It made no attempt to process the evidence it had in its possession. It didn't look into sort of key matters. I mean, if you look at the report, Jacob Zuma isn't mentioned in the report, which is crazy because he is at the center of a very well-known corruption scandal involving the arms deal, and that was just totally ignored. Shabir Sheikh isn't dealt with at all. Tony Ngeni isn't dealt with at all. And I think another issue was that when they did call witnesses who were accused of corruption, they didn't question them. So they would call somebody like Fanach Langwane, for example, or Chippy Sheikh, and they'd basically let them read their statement or be led through their statement, and the Commission wouldn't really ask them any questions, which would sort of be like, imagine if Judge Zondo called the Gupta brothers to appear before the Commission, the Zondo Commission, and just let them read prepared statements and didn't ask them a single question. People would be outraged. And that was just one of the many different failures. They refused to admit documents that were absolutely relevant to their terms of reference on spurious grounds. They didn't allow witnesses like myself, proper time to prepare for cross-examination. They refused to supply any documents to people like me, even though we were constantly being brought up in the proceedings. It really was a total and utter failure to conduct any sort of meaningful investigation.
Yeah. Now, it's reported, I've not listened to this interview myself, I must confess, but in a radio interview that Judge Seriti has said that the report, close to 1,000 pages, explains exactly what I did, how I did that, and why I didn't do certain things. I cannot add or subtract from that. I mean, what do you make of that as a response to the questions?
I mean, I thought that was a very inflammatory response, and we actually made that part of our complaint to the Judicial Conduct Commission. I mean, you have a situation here where you have two judges who have been asked to preside over an investigation into one of the most profound and biggest political and corruption scandals in South Africa's post-apartheid history, who have vast resources and spent a huge amount of money, 130 million rand, effectively doing very little besides for asking for some statements and not looking at evidence. And that is a very profound failure. So for Judge Seriti, after the report to be set aside, to sort of brush it off as if it's nothing, as if the High Court finding is just, a judgment that's been set aside. It speaks to his failure to understand what a commission of inquiry is, first of all, because his inquiry wasn't a judgment. It was an investigation. It wasn't a court case. He wasn't supposed to be conducting an adversarial litigation. It was, he was supposed to be finding out the truth, and he didn't. And the High Court said, you didn't find out the truth. And I think it's totally unbecoming that we have this incredibly damning judgment, which raises serious questions about the judiciary's competence. And it's just brushed off. I thought it was an absolutely outrageous response. Yeah. I mean, he says that the report is 1,000 pages. I mean, it is 1,000 pages. 100 pages of it is him excusing himself from not doing any work in the first 100 pages. The final 100 pages is basically saying, I find nothing wrong with the arms deal. And about 800 pages is just summarizing the testimony and witnesses who appeared. So this idea that it was 1,000 pages of rigorous discussion is just ludicrous.
Of course, the other question it brings, I know you're saying it brings a question of competence of judges, but the thorny issue of judicial independence and accountability. At face value, Mbekezeli, it sounds as though the two principles are incompatible. However, they are linked in a sense. Do they really help to reinforce and promote public confidence?
Yes, they absolutely do, Thabo. Actually, the principles of judicial independence and judicial accountability go hand in hand. Judges are supposed to act independently without any fear, favor, or prejudice to anyone, but they must also be held accountable for the decisions that they take. So take, for example, ordinarily, when a judge is deciding on a case, if they get the case wrong, it is taken on appeal or it is taken on a review in a higher court. Now, when a judge is performing other functions, such as the commission of inquiry, that's where the sort of principles get a little bit blurred, because the commission of inquiry is not a court of law and is not supposed to actually use the court of law when it's doing its job. It's supposed to inquire. It's supposed to use a more flexible process to get to the truth. But at the same time, the judge or the presiding officer must remain independent. And when they fail to be independent, there are allegations that they may not have exercised their mind independently, then the accountability kicks in. A system like the conduct complaint is one way of holding them accountable, but also taking the decision on a review is another way of accountability. So in this instance, Corruption Watch and Right to Know have taken the report to a court of law where it has been set aside, and that judgment was quite critical of the commission, and so that was one leg of accountability. So the complaints by Shadow World and Open Secrets is just another leg of accountability, and both of which are important.
Yeah. Now, broadly, we have been hearing complaints from politicians, but also from others within the legal profession who have been raising concerns about the potential threat to the independence of the judiciary. These matters sharply raised, particularly, for example, around matters of conflict of interest. What do the codes say around that, Mbekezeli?
So this particular case, I'm not too sure whether it raises a conflict of interest as yet. We really don't know what the judges have to say for themselves for how they've behaved. You made reference earlier to a radio interview. I think that's as far as Judge Seriti has spoken. So in this upcoming process, he has to submit an affidavit, and he will set out his position quite clearly, and that's where we'll see whether or not there is a conflict of interest. But on a general point, there is a judicial code of conduct which says that the judges must avoid any conflict of interest or anything that will give rise to a perception that the judge has a conflict of interest or is not acting independently. Like I said, in this particular case, we're not sure exactly whether that allegation can hold up necessarily.
But I mean, if a complaint says 4.7 million pages of evidence, 460 boxes were just ignored, they just remained untouched, would that be in keeping with the judiciary's mandate, the role of dispensing justice independently without fear or favor?
Well, it speaks to something called judicial competence and diligence. A judge is supposed to work diligently to consider all the evidence that is put before them, and they must make a determination of any of the evidence that is put before them. And the allegation, as I understand it from Shadow World and Open Secrets, is that there wasn't competence in the way that they carried out their responsibilities in the commission, which is why there's now a complaint. Obviously, the complaint still has to be attested through the Judicial Conduct Committee or the tribunal, and we'll then hear exactly to what extent they were incompetent. But at this stage, if there's a allegation that they did not consider evidence that they were supposed to consider, then it speaks to issues of diligence and competence.
Mbekezeli Benjamin, he's with Judges Matter with us tonight, as well as Paul Holden. We'll continue the conversation in a moment here on the Newsfeed Late Night. Let's get your views tonight on Twitter at Newsroom405. Otherwise, you can send us a WhatsApp message, 072-110-5584. We continue for you in a moment. Back with you, back in the spotlight, the question of the independence and accountability of judges in their practices and processes in conducting their work. This, as the Judicial Conduct Committee has allowed, of course, Shadow World investigations to have their matter heard around the complaint they are putting forward for Judge Willie Seriti and Judge Hendrick Musi on the Seriti Commission matter. Now, Paul, who should be regulating the practices and procedures of judges, particularly in this particular case when we're talking about extrajudicial activity?
I think in this case, we do have the Judicial Services Committee and the Commission that will oversee and hold judges accountable. That's the constitutionally designed mechanism to ensure that they are held accountable, which is precisely why we've submitted our complaint there, because they are the appropriate body to oversee it. And, their findings on the matter are effectively final. I would like to add that, our complaint is not necessarily about trying to find out whether the judges conducted an investigation or not. That's already been decided. That's a legal fact. We know that they didn't conduct an investigation. Our complaint and our inquiry really to the JCC is to say they didn't conduct an investigation. We think that amounts to incompetence or misconduct. Do you agree? And that's what they have to rule on, and they are the appropriate body to do so.
And is that the right instrument, though? Many have been questioning, particularly as you mentioned earlier on, the process, for example, of going through the Judicial Services Commission and how that process can take even years before a matter is concluded.
I get your point. Sadly, that is the only instrument that we have to use at this point. So we have to take it and use it warts and all. But I do agree that it's not moved with any degree of speed when it comes to these sort of matters, and has often been sort of constricted and constrained by sort of extraneous concerns, but political concerns in particular. In the end, you have to consider that the JSC is ultimately a political body. And as such, it falls into a slightly odd position of being a political body that has to decide the conduct of independent judges. I have to admit that I'm not an expert on the constitutional arrangements and what should or shouldn't be tweaked when it comes to the Judicial Services Commission. I'm sure your other guests can speak to that. But I do think that this case needs to be heard speedily. It needs to move through this process fast, because other ones haven't. And I think it's really important to show that cases like this of serious incompetence or misconduct are treated with the gravity they deserve, and there is actually justice that gets seen to be done within a reasonable time frame.
Yeah. There is a meeting, Mbekezeli, that happens periodically called the Heads of Courts meeting, which is usually chaired by the Chief Justice, that looks into these issues of the effectiveness of the courts and in other administrative issues as well. And there's been talk around whether or not administration of the courts should actually be a responsibility that falls on the courts themselves or an independent body. Where are you on that debate?
Look, Thabo, that debate has been raging for some time. And in fact, there was a process that was initiated at the start of the current Chief Justice's term of moving towards what is called judicial-led administration. So judges themselves running the courts. And that process is sort of stuck in between. You rightly mentioned the heads of court as being a governance structure, but really what should be the correct forum is called what is a judicial council, where the judges themselves will be represented at all levels, and they'll be in charge of running the courts. But like Paul said, there is a constitutional structure that deals with issues of misconduct, and the Judicial Service Commission is that body. And I do agree with Paul that it does take a long time to deal with cases, but I would slightly disagree with Paul in terms of it being a necessarily political body, because only when it considers complaints against judges are the politicians not involved. So members of parliament are not involved in complaints against judges. Only when they reach parliament will they be involved, but ordinarily they are not. Of course, this does not take away from the concern that the Judicial Service Commission and the Judicial Conduct Committee takes far too long to deal with complaints. This particular case, it was filed in August, and only now do we hear a decision about this complaint moving from the first stage, because this is only the first stage. There's still a few more stages to go. And so that is the concern that we have.
Yeah. Talk about where the politics and the judiciary collide. There are lots of talks these days. I think some of them were even leaked via the NEC deliberations of the ANC that took place this past weekend. The organization lamenting the fact that they are losing ground in the courts, and they are reversing some of the decisions that they had previously warned because they are not focusing on the correct issues. I don't know what that actually means, but there is, of course, that feeling that there continues to be this tension between the politicians in the country and the judiciary. Is that a normal occurrence in a democracy?
Yes, in a constitutional democracy, there's supposed to be checks and balances. So the judiciary is supposed to hold parliament and the government accountable. Parliament is also supposed to hold the other arms of state accountable. So there should be a tension, a healthy tension between the arms of state. Where it becomes unhealthy and quite destructive is when members of one body attack members of the other body. And that's where it becomes unhealthy, because public confidence in the institution is also affected. An institution like the judiciary is a little bit more vulnerable to those kinds of attacks, because judges ordinarily cannot respond to political attacks. And in fact, we don't want our judges to respond to political attacks. We want them to speak through their judgment and to decide on issues of the law. And so the tension that exists must be based on mutual respect between politicians and judges, and there must also be a realization that there is interdependence between parliament, the judiciary, and the government, the executive. They should all work together towards achieving the goals in the Constitution.
Yeah. Is there also that tension that exists within the judiciary itself, right, to want to speak truth to power without fear or favor? In most instances, you hear judges, even at the top level, saying, well, why do you want me to conform to a certain way of doing things? I should be able to say and speak things that are in my mind as they are.
Well, if the judge is deciding a case and they are considering issues of law, obviously each individual judge within the judiciary has their own independence. So judicial independence operates at an institutional level where the judiciary has to be independent, but each judge has to arrive at whatever decision is before them independently without influence from any other judge, which is why you see sometimes in court judgments there will be something called a dissent, where one judge takes a different view on the same issues. So they are allowed to do that, but obviously they must explain through cogent reasons why they arrived at that decision.
Yeah. And Paul, the role then of civil society in that conflict and the role that they would play in reinforcing the independence and accountability of the judiciary, but also in building the confidence of society.
And I think civil society is actually fundamental to ensuring a functioning judiciary. And I think civil society can perform what may seem like two contradictory functions, but actually two complementary functions. The one is to relentlessly hold the judiciary to account, to ensure that they do adopt and they do perform to the highest possible standards, and they are independent. But at the same time, it's also civil society's role to protect the judiciary when it comes under unfounded, unwarranted, and politically motivated attack. And in that sense, civil society is relatively privileged in that it can play that role that judges may not be able to because they have to remain silent on issues of the day. Civil society acts, I think, as a moderating influence on those two sort of competing needs, which is one is to make sure that judges do their job and be critical of them if needs be, but at the same time, defend those same judges from unwarranted criticism. And obviously that's a complex political issue, and that gets debated. And what is a good judgment, what is a bad judgment? That is part of the nature of our democratic experiment, right? That's what we do. We debate, we argue. But the point is to protect the judiciary from attack that undermines it for ulterior purposes. And isn't grounded in fact. And I think that's the real key role that civil society can play.
Yeah. Mbekezeli, how often do we refresh those rules, right? There's a question around rulemaking and how, for example, the Minister of Justice and Correctional Services should not be involved in the rulemaking as far as the conduct of judges is concerned. But how often do we refresh those? How often do we refresh our adjudication processes and our accountability processes, and whether or not they are, in the current environment, due a relook?
So in terms of the law, the Chief Justice is supposed to review the Code of Conduct for Judges every 5 years or so. And they should check whether it is still working, whether it is still achieving the objective that it's supposed to achieve, and if it's not doing so, must change the rules. And so there's a legal obligation on him to do that. But ordinarily, even when the court system is operating, there are rules of procedure that exist in that court system, and it is reviewed by a special body within the legal profession. It's called the Rules Board, and it checks the rules and refreshes them as and when is necessary. But obviously, there is supposed to be a requirement within the judiciary that it cares for that the court cases are dealt with fast, quickly, that legal issues of the day are dealt with fairly by all parties concerned, and then the public must have confidence that that is done. And so the judiciary has to constantly be aware of issues of access to justice and promote access to justice in its rules and procedures.
Mbekezeli, I appreciate your time and thank you very much for joining us tonight, as well as Paul Holden, Director of Shadow World Investigations, of course, helping us through that very thorny issue. Judicial accountability back into the fore, and I suppose it will remain for a while, including the tensions that continue to exist between high-profile political players and our judicial system here in the country. We'll recap for you what's making news this hour here on the Newsfeed Late Night when we continue next. Stay with us.